Hello, everyone. Welcome to today's Bprc Industry Breakfast. My name is Rob Nickel. I'm the Bprc manager, and I'd just like to welcome everyone here today. And Julia, I think if we start the PowerPoints. Great. Thanks so much. So thanks for attending today. We have two great speakers that I will introduce in a few moments. First, a little bit of background about us at Lambton College. We are the Bioindustrial Process Research Center, Bprc. We're within the Research and Innovation Department at Lambton College. We are a research center, but one of a few. There's a manufacturing research center, a water research center, a IT research center, and an energy research center as well. So for today, it'll be bio-focused. Who we are? Well, we are a large team of researchers. We also have a lot of people in the office. We have a very busy office and lab. So in the office today, we have Julia and Ian who are helping with this presentation today over Teams. So thanks so much, Julia and Ian. What we do? Well, the Bprc does applied research projects, innovation, technical services, and specialized training. The applied research projects work usually with an industrial partner, a private sector partner. Maybe your company has a small technical challenge or some new product development that they want to have completed, but don't have that capacity, their personnel or infrastructure to do it. Well, we can potentially do it at Lambton College. That's within usually an externally funded research project with a defined timeline. Maybe things that aren't as defined in terms of timeline. We might offer some technical services in analyzing things, or maybe building new business models or business connections with other partners. And we also do specialized training. So one of those examples is we recently have a cannabis license from Health Canada, and right now we're developing new cannabis courses for training a lot of cannabis workers in product analysis and chemistry and hitting those compliance marks that are needed to bring cannabis products to market. So that's what we do. I talk a little bit more about the applied research projects. So we do have a lot of research infrastructure at Bprc. We have 4 labs, a materials lab, a pilot lab, a water lab, an analytical lab, and a fermentation lab. So this fermentation lab is shown on the left. We have a large fermenter. That's a 32-liter fermentation vessel. It's all controlled. We have smaller fermentation vessels, and on the other side we have showing a lot of our chromatography analytical equipment. So we have a lot of capacity to do fermentation, chemical analysis, and a few other main themes as well, which is on the next slide. So we usually work within these 5 themes: fermentation and distillation, biofuels, biochemicals, and biomaterials, pharmaceutical products and natural health products, instrumentation and process control, cultivation, extraction, and chemical analysis of plants mostly. So right now we're very busy, very active. COVID-19 slowed us down a bit, but we've been back and up and running mostly as business as usual for quite a while now. So very active lab in these 5 themes. We have currently 10 companies, 10 individual companies or discrete companies working on projects around fermentation and distillation. We have 11 companies working in the biofuels, biochemicals, biomaterials area. Some of these projects are developing new biodegradable plastics that can be used for packaging. We have 3 companies working with us in pharmaceutical and natural health products. We have 2 companies in instrumentation and process control. One of them is a local Sarnia company that's rearing black soldier fly larvae for sources of protein and lipid. So we're working on making an automated insect cultivation and harvesting unit with that company. And we have 6 companies in the cultivation, extraction, and chemical analysis theme. One of them is a cannabis grower, a nearby cannabis grower, where we are helping them optimize their cannabis plant production, which is a big step in terms of that crop coming in every so often. You really need to optimize how many seedlings you can get per cohort. So we're helping them with that. So a lot of things going on. I always say that the B in Bprc stands for bio. So if you have other ideas, other themes, other ideas you want to explore, please give us a call. We could probably help you with anything bio-related, and if we couldn't help you, we might be able to put you in touch with one of our other research centers as well. So that's what we do. Part of what we do also are these networking events and information translation events. So today I'm very happy to welcome two IP specialists. We're going to talk about IP, or intellectual property, especially within the realm of small and medium enterprises, and what exactly is IP and how can your company benefit from having a better IP strategy. So today I'd like to welcome Sipal from Carter's Professional and Himja from Origin Materials. Sipal did a biology degree at University of Windsor, then moved off to Ottawa to do her law degree, and she's now a partner at Carter's Associates in Ottawa, where she practices exclusively intellectual property information technology law. Welcome, Sipal. And Himja is working at Origin Materials, where she specializes in patent litigation and licensing. Himja is focused on the IP strategy and working with scientists at Origin Materials to identify patentable technology. So welcome also to Himja. Today we're going to start with Sipal, and again, thanks to everyone for attending. Thanks for our great speakers we have today. And Sipal, if you're ready, I will hand it over to you.
Great. Well, thank you very much. And thank you for having me today. It's a real pleasure to be here and speak about this topic with everyone that's logged on. So you'll notice when I go through my presentation that there's a lot of content there on the slides, and that was intentional. So I'm hoping that the slides will act as a resource tool in the future for you to reference. But today I encourage you to just sit back, follow along, listen, and I'll try to give you some practical examples that I've seen over the years that will hopefully help you navigate this really interesting area of the law. So next slide, please. Great. So on the slide in front of you, you have a brief overview of IP rights. IP refers to intangible creations of the mind, and the main types of IP are trademarks, copyrights, patents, trade secrets, and industrial designs. I will be going over trademarks and copyrights today, and Himja will cover patents and trade secrets. These forms of IP are assets, okay? They are one of your enterprise's assets, and oftentimes one of the most important assets that your enterprise may have. IP can generate income for SMEs through licensing, sale, or commercialization. In the event of a sale, merger, or acquisition, IP assets may significantly raise the value of the enterprise and at times may be one of the only true assets of value. However, like any physical assets that you may own, IP assets need to be acquired, maintained, accounted for, valued. They need to be monitored closely and managed quite carefully in order to extract their full value, and also in order to avoid any potential liability in the future. Next slide, please. So IP rights are very important elements that SMEs should take into account. There's two major reasons for this. On the one hand, it might be important to register a certain type of innovation or new work or process that is being used so that it won't be copied by competitors. Otherwise, other companies may take advantage of the efforts made by the SME in developing the new area. And this factor is one of the primary reasons why an SME would consider even listening to a topic like this. However, something that's quite important and often goes underappreciated is that it's critical for SMEs to be acquainted with IP systems to avoid getting involved in activities that border on illegal. For example, I had a client where a fruit producer was using patent-protected seeds without paying the pertinent license. Obviously ran into significant, very costly legal problems. Next slide. So the first type of IP I'd like to discuss are trademarks. So what is a trademark? So a trademark is a symbol of your identity. It embodies the goodwill and the reputation of your enterprise. and it is any mark that can be used to distinguish the goods and services of one organization or enterprise or individual from that of another. It can be a word, a design, a slogan, a color, any combination of these things that kind of represent your enterprise. All organizations and enterprises typically do have at least 1 or 2 trademarks, which would be your name and likely your logo design. Consider something like the iconic McDonald's logo. Even if a 10-year-old sees that logo at a distance, they instantly know that they're not far away from a Happy Meal. So, just keeping that example in mind, it's very clear that trademarks are extremely powerful and help the public make decisions regarding what enterprise to support, work for, donate to, purchase products and services from. Next slide, please. So a few things to note about trademark rights. So the first thing is the branding cannot be confusingly similar to another company's trademarks. The language here is confusingly similar and not just identical. Another thing to remember is trademark rights are technically owned by the first person or organization to use that particular trademark in a particular country. So they are national rights. There are tools such as trademark searches that can help to uncover third parties that are using similar marks. Something I tell my clients that they can do without the assistance of legal counsel is your own due diligence searches. So you can go on the Canadian Intellectual Property Trademark Database and you can do a search for registered trademarks. So what you would want to do is try all different variations and spellings and phonetic equivalents of your name. And then you want to do that same sort of search on Google as well. I'll explain the importance of ensuring that a trademark is not confusingly similar to another company's trademark shortly. But once a trademark is selected and cleared through searches, the next thing I would recommend is registering the mark with the Canadian Intellectual Property Office. Next slide. Perhaps the most important advantage to registration is that it provides a presumption of ownership, which I will get into shortly. There are several other advantages to registering your marks that I have set out on the slides for your review. Maybe if you're having trouble falling asleep one night, you can review those. I'm sure they'll put you right to bed, but those are there for you to take a look at. Next slide, please. So let me walk you through an example that I have seen time and time again. You've been happily operating for a few years. You have a pretty well-known brand in a particular area of Ontario, perhaps. You even have a corporate name that you've registered. You didn't think trademark registration is necessary since you're so well known and you have your corporate name. All of a sudden one day, someone comes knocking and says, hey, I've got a trademark registered, I own it, and you need to rebrand. So now what? Well, technically you were the first user of the mark, so you have strong, unregistered, or what we call common law trademark rights. But that means you need to hire a lawyer, you need to go to court, and you need to prove through extensive evidence of use that you own the mark. This can cost you upwards of $80,000 or more, and in the end, you may still be forced to rebrand. So registering the trademark early on could have avoided all of that and provides you with an automatic assumption at law that you own the mark. So on the flip side, if you were not the first user of the mark and you've been happily using it for years, perhaps, and a third party comes along and tries to sue you because they were actually the first user of the mark in Canada, maybe 15 years ago, you just never knew they existed because they operated in some small town like Windsor, then you have a big problem on your hands that'll make trademark lawyers quite happy for a long time because you could be on the cuff for damages and all sorts of nasty things. So at a minimum, even if you don't want to spend the cost in registering your marks, I would highly recommend that you just do your own due diligence searches by going on the Canadian Intellectual Property website and also by doing Google searches to ensure that there's no one else using a confusingly similar mark that predates, when you started using it. Next slide, please. So now moving over to copyright. So copyright is a form of intangible intellectual property, or in other words, a creation of the mind. It protects every literary, artistic, dramatic, or music work. So there's a host of different types of work that can be caught under these categories. A very common example is computer software, for example, coding, that sort of thing. Obviously, anything that's written, anything that's drawn, all of that good stuff. And it provides the owner of the work with the exclusive legal right to reproduce, produce, publish, or perform that original work. And only the owner of that work is permitted to do this, and is permitted to allow others to do this as well. Next slide, please. So first, the great thing about copyright, and actually trademark protection as well, is that it can arise automatically. So as soon as you write the work on paper, or if you start using a particular trademark, for example, and it's not just an idea anymore, copyright or trademark protection attaches to it. Another way to protect your copyright is with a registration certificate from the Canadian Intellectual Property Office, which again creates a presumption that you own the work at law. And registering a copyright similar to trademarks offers numerous advantages. Next slide. So an example that is common is that many enterprises run into issues way down the line after they've been operating for a few years regarding work that was created by the company and determining who owns the copyright. So this is a bit confusing, so just try to stay with me here, and if you have questions, please fire them away. Generally speaking, the author of the work is the owner, unless there's an exception to the contrary. The author of the work cannot be an organization or an enterprise. It has to be an actual individual. So the default at law is that the author, whoever penned it or wrote the computer software or whatever, is the author of the work. However, there's one exception to that rule, in that work created by an employee in the course of employment vests in the employer. So work created by any employees that you may have is generally owned by the enterprise. However, the author, so the individual, retains certain what we call moral rights in the work, which includes a few different things. One is the right to be attributed with the work whenever they want. So it's important to remember that this exception, though, is only for employees. So it requires a very typical employer-employee relationship in the eyes of the law. So what that means is that if you are working with independent consultants or volunteers, contractors, any of those parties, the copyright does not automatically vest in the enterprise. The default for those situations is that the third-party contractor owns the work. Many of our clients are quite surprised to find this out. They assume because you are paying a consultant to do work, or a website developer, or whatever, to produce some sort of copyright content, that they own it because they paid for it, but that's not the case. So as a result, just be mindful of this when you're working with third parties such as volunteers or consultants and that sort of thing, that are creating maybe publications or, like I said, website or logo designs, computer software, that sort of things. For those individuals, the enterprise will need to get an assignment of copyright and a waiver of moral rights. Next slide. So the last topic I want to briefly touch on is leveraging IP. So the way I describe IP to my clients is that they are a tool in your toolbox. So you have patents, trademarks, trade secrets, copyrights, etc. So depending on what you're doing, what countries you plan to be in, what you're trying to protect, you have these different tools that you can use. So be it trademarks or copyrights or patents, or maybe a combination of all sorts of different IP. So on the screen, I've listed some strategies to leverage your IP. So for example, franchising, a capital investment option for you to expand your company. Technology and brand licensing allows you to generate licensing fees and obtain royalty income. There's strategic partnerships that work by joining into joint ventures or strategic alliances with enterprises that have common business objectives. or something like a co-branding, which allows two companies to combine their ideas and come up with a new product or service and that sort of thing. Next slide. Oh, next slide, please. Perfect, thank you. So lastly, I'm just going to walk you through two examples of Canadian companies that have leveraged their IP to gain success. The first is Spin Master, which is a toy company that created Hatchimals. If any of you have children, you may be familiar with Hatchimals. Spin Master only uses the long-term and expensive protection of patents selectively and actually relies on trademarks and trade secrets to protect against counterfeiting. Another is Vectra, and they are a chemical manufacturer in PEI. So typically patents are more frequently used in the biotech industry, but this company actually relies on trademarks and trade secrets to protect its investments. So as I said, depending on what product or service or technology you're dealing with, you have different tools in your toolbox to protect your assets. Next slide. So that concludes my presentation. Thank you very much again for having me, and I welcome any questions that you may have.
Thanks so much, CPAL. I was interested to learn about that copyright and even contracting someone and paying them for that work. It's not necessarily yours. I did not know that. That's interesting. The format for today is we'll take some questions from the audience after each speaker, and then we can, if other questions arise, we can take do another question session after Himja as well. So right now, do we have any questions? I have a question about, are we recording this so we can share? Yes, we are recording this. And Julia, who organized this, will also be able to share that link with everyone afterwards. Do we have any questions for CPAL right now? I don't see any. Okay, so please think of more as Himja speaks as well, and we can maybe come back to CPAL after the next talk as well. Thanks so much, CPAL. And I'd like to welcome Himja now from Origin Materials.
Sure.
Himja, thanks so much for coming today, and are you ready to take it away?
Yes.
Okay, great. Okay, great, thanks.
Yeah, I'll just start sharing my screen for my PPT. Can you see it?
Yes.
Yes.
Okay, perfect. So good morning, everyone who's watching this, and thanks Rob, Julia, and team for organizing this. I'm very happy to speak today on patents and trade secrets for SMEs.
Thanks, Himja. You might want to hit presentation mode.
Sure.
Yeah.
This fine?
Yep, that's great. Thank you.
Perfect. So today I'm going to talk about patents and trade secrets. So I'll get started with the basics first. So a patent is a form of intellectual property that gives a negative right to the holder to exclude others from doing something. And this is usually for a fixed term. Often 20 years is common in countries including Canada. So a patent is basically in the nature of a quid pro quo, or an exchange between the sovereign and the private individual who's invented something, to ensure that good inventions can come into public domain after the expiry of the term. And as a consideration, the holder is granted 20 years of what is commonly called a monopoly. And there are several benefits to obtaining a patent. including gaining exclusivity in doing something. Although patents per se do not give affirmative rights, you can block your competitors and get significant economic advantages. If you don't plan to practice your patented invention, you can also monetize it by licensing it and giving rights to other parties to use it, and generating revenue through royalties on these patents. Public welfare benefits, it fuels the advancement of science and technology. However, not everything can be patented. So I'll go over the requirements of patenting. Okay, so there are broadly 4 requirements. The first one being patentable subject matter. So every country's patent office fixes what is patentable subject matter and what is not, often depending upon the morality standards and public policy norms in the country. So a product, a composition, a machine, a process, or an improvement on all of these can be patented if the next 3 requirements are met. However, very general things like abstract theories or methods of medical treatment or surgery that nobody should be granted a monopoly over are usually considered non-patentable. Oftentimes, living organisms upwards of microbes are also considered non-patentable. So if somebody in a laboratory, if that's even legal, tries to clone a human being, there cannot be a patent on that product because it's just considered unethical to have a patent on that. However, once you check this box, you have either of these patentable subject matter items. You still need to prove 3 more things. The first being new or novelty. So it has to not have existed in prior art before. So if there is any article out there, or if there has been any prior patent out there that discusses a similar thing, then it's difficult for you to prove that what you are claiming is new. So make sure that it's novel. Next is useful. So patents are usually granted for inventions that have utility and often on a commercial scale. Many countries have a requirement that these be industrially worked. So you need to prove how your invention is useful. And it does not have to be useful to the society or public at large, but it has to be useful to meet the legal aims of your business. The last one is that it has to be inventive. This is also known as non-obviousness in the US and some other countries. So if your invention is it's so obvious that someone who is reasonably skilled in the field can just guess it and be like, oh, I could have thought of this, then that's not going to be non-obvious or inventive. So you need to meet these requirements. And also I'd like to flag that Canada follows first to file system. So even if you invented something first, but you were second to file it before the patent office, you lose the rights. If somebody invented it later than you, but goes ahead and files it first, they get the patent. So you have to be quick in patenting. However, I should flag that since the term patent rights is often used as synonymous to monopoly, it is important to understand that there are certain limitations and it's not in the form of an absolute monopoly. So I would like to clarify 2 things. First, that it is a negative legal right. It is not an economic right. It does not give you an economic monopoly. So you still have to use your market sense and commercialize it in a way that yields profits, because a patent is no guarantee for commercial success. As an example, if I invent a mouse trap, well, it's obvious by now, somebody already has. But if I invented it and it met all the requirements, but I price it as at a very costly rate, then people will just start buying cats. So you still need to use your commercial sense and time it better. Okay, next is that there's no such thing as a worldwide patent. So patent protection is still a local game. So the exclusive rights that are attached to a patent are only applicable in the bounds of the country which has awarded the patent. However, in recent years, World Intellectual Property Organization has made significant efforts to come up with a unified application system. I should clarify that this by no means guarantees patents in all the countries that you file it for, but it simplifies the process of applying to each of your selected nations. What you can do is you just need to file one application with WIPO. They will review it. After they've reviewed it, there's a window which is called the national phase window, and you can select as many countries as you want in this window, and those applications will automatically be considered by the patent offices. You still might have to make amendments to meet the individual laws of that country, and you also have to pay fees for each of these patent offices. But it just saves you from the trouble of filing new applications in all these different offices. So that's the PCT system. And I have a slide at the end for useful links, so you can find this there. This might be very useful if you are looking to target multiple geographies for your product or process. Okay, next is business considerations. So to patent or not to patent from a business perspective has to be a cumulative assessment of many factors. For example, if you don't want to get a monopoly, is there a non-infringing alternative technology available that you can just use and get your job done? And you don't want exclusivity, it's not so important to you, then skip patenting probably. Does the patent give you an important competitive advantage that you are seeking? Is there a rival out there that you absolutely want to block and that would yield great profits for you? Yes, then sure, go ahead. If you're just looking for third parties to not get a patent, but you don't want exclusivity, a cheaper alternative is just publishing it, because if something is published, other people cannot get a patent over it. So if all you want is your rivals from not getting monopoly over it, so that you can continue practicing it, you can just publish it and you don't need to patent it. Budgetary constraints, of course, need to be considered because patenting is expensive. A huge chunk of this is attorney fees, and it's almost always required because you require specialists to look over a patent before it is sent to the PTO. So these are some of the considerations that you need to take into account. I'll move on to, so this is where trade secrets comes in, because trade secrets, there's no registration fee. You don't really need to maintain a trade secret in terms of filing annuities. To maintain a patent throughout its term, you need to file annual fees with the patent office. So to cut down cost, there's another alternative, trade secrets. However, it comes with its own sets of cons. So I'll start with the definition of trade secret. So a trade secret is information that has economic value from being a secret. So its value resides in the fact that it is hidden from your competitors. And second requirement is that the holder should take reasonable efforts to keep it a secret. So if I just show you this slide, these are examples of trade secrets. You would think that trade secrets only covers foods that are insanely tasty and unhealthy, but that's not limited to foods. It can be anything: a pattern, a compilation, a program, a device, a process, a customer list, manufacturing processes, blueprints for machines, and so on. But it has to be some information. It needs to have economic value, and such value should be attached to the non-disclosure of the information. So it need not be an absolute secret, but it should not be easily known in the relevant group in the industry. So if everyone in your market, sub-market knows that, okay, A plus B gives D, for example, and not C, then that's not really a trade secret. People have already figured it out. Lastly, you need to have reasonable security measures. However, it is important to note that in Canada, there's no statutory protection for trade secrets. So you need to rely on common law principles to get remedies for misappropriation of trade secrets. And so the Canadian Intellectual Property Office, in fact, recommends that holders take all security measures possible and not just reasonable security measures. So if you're in Canada, you need to be extra careful about protecting your trade secrets. Sorry. Okay, here we go. It's important to note that trade secret does not give some of the advantages of patents. The first being that you cannot stop others from independently arriving at the same information that you are holding. So unless and until it has been obtained by a breach of confidence or breach of fiduciary duty from you, it has been stolen from you in some way, you cannot really stop others from or block others from developing it, or even getting a patent over it. Other people are free to do that. It is not exclusive, like I said. There's no application required, and it can be held infinitely beyond 20 years, 100 years. Coke has been held as a trade secret for more than 100 years now. So there are some advantages if you are confident that you can be very cautious that there are no leaks of this information. Trade secret protection is particularly appropriate in certain situations. For example, if you have an invention that does not meet one or more of the 4 patentability requirements, you might want to hold it as a trade secret. If you have an invention that you plan to patent, but it's not really ready to be filed, during that interim stage, you can hold it as a trade secret to ensure that it's protected until the patent is granted. Yeah, just one thing to note here, that products are not really good for trade secrets protection because it's very easy to reverse engineer them. So if you have like a process that has multiple steps that are not really commonly known, then that might be apt for trade secrets protection as opposed to products. There's also a strategy to combine patents and trade secrets for complex inventions. So I've taken 2 examples, the McDonald's burger and Nutella. So the centerpiece in each of these products, being the Big Mac special sauce or the overall formula to obtain the Nutella paste, they are held as trade secrets, but the ancillary inventions such as the method and apparatus to make a burger or process of manufacture of a honey composition, they are held as patents. So, and this is also very common in the biofuel industry. So, for example, it's common to have patents over bioreactors, but the exact identity of the microorganism that is being fed into the bioreactor is usually held as a trade secret because companies don't want it published. So Yeah, and this is my last item, evolution of IP strategy. So as a company grows financially, it has more budget, more experience, and it's important to continuously revisit IP strategy at different stages of growth to ensure that all your IP assets remain protected, to identify new IP assets, and also to see if there's potential to monetize your assets via licensing, because that can be a very lucrative way of generating revenue from your IP assets. So this is just a bunch of links that you can go over later. And yeah, any questions?
Great, thanks. Thanks, Himja. I love the liberal use of cats. Excellent.
Thank you.
And thanks so much to Himja and CPAL. For the audience, if you're not aware, there's a little Q&A button, usually right along the top, and that's how we're getting your questions or comments, so please type them in if you have them. Himja and CPAL, thanks so much. I'm getting lots of comments here about thanking you and great job, and I'm getting requests about how do we book you for other events at other organizations, so thanks so much again, that is great. We do have some questions as well, and I might steer them just, I'm guessing to at the time they came in, and I'm guessing to who they go to, but if the other speaker wants to jump in too, that's fine as well. So earlier on, so I think this is for CPAL. Could you, so I think just maybe a comment on a little more information of patent protection for a software company. I know you covered it, but maybe a little more details around patenting software or software company, the implications there.
Is that for me?
I think it's for CPAL, but anyone.
Oh no, CPAL, go ahead.
No, Himja, go ahead, because I'm not. You're the patent expert, so I'll let you.
Okay, fair enough. Yep.
Okay.
I mean, I can add some comments at the end, but go ahead.
Sure. So I should have clarified this, but I'm not licensed to practice in Canada. So my understanding is based on general IP principles and US laws. Softwares are patentable. However, I know that in Canada, computer code is not considered a patentable subject matter. Yeah, my understanding is that software are patentable, but I'll defer to CPAL because I don't know much about Canada law.
Yeah, so you can I guess generally the same principles would apply if it's new and non-obvious invention. You could get patent protection. It's quite challenging and difficult, though, just because of the nature of what it is. So computer software usually would fall into, well, 100% it's copyright protection there for sure. And if you're doing something like an application development or that sort of thing, there's also industrial design protection. And that would cover not the coding, but that would cover the look and the feel of the app and the website or whatever it is. So yeah, I mean, those three are all available for sure.
Okay, great, thank you. I think for maybe either speaker, could you compare the cost of patenting versus trademark protection?
I'm sure patents are way more expensive, but I'll let CPAL weigh in.
Yeah, so patents are, I mean, I don't do patents myself here in the office. We work with an external counsel, so I'm not overly familiar with costs, but it is quite costly. I've seen my clients spend, upwards of 10,000s, for patent protection, just depending on if it runs into any issues or that sort of thing, and how technical, the invention is. And I think the question was to compare it to trademark costs.
Trademark.
Yeah, so trademark costs are quite reasonable. The cost for trademarks depends on the number of goods and services that are in the application. So government fees, I can tell you, for one class, which is a bit of a technical term, it's $330 for the filing fee. And then every additional class is another, $150. And the classes just refers to categories, basically, of the goods and services, because every trademark, I don't know if I mentioned this, but the protection and the rights that you get are always tied back into the goods and services that are in the application and that you're using the trademark with. So it's not, you know, exclusive rights with everything. So the cost always goes back to that. And then, so yeah, I mean, it's much more manageable in terms of cost than patents, that's for sure.
Yeah, to add to Seepal's point, in patents, often it depends on how many claims you have, because in US, we have a rule that if it exceeds 20 claims, you have to pay $100 per every claim after the 20th claim. And also, like Seepal mentioned, it depends on how many problems you run into, which means that how many objections the patent office sends you back. So if, for example, there's a lot of back and forth, then the attorney is going to charge you for filing responses. And also there's fees to be paid with each of these correspondences. So it depends on how much back and forth there is with the patent office.
Okay, great. Thank you. So here's one, it's a bit nuanced. If we hire a company to make a widget that we designed, who owns the IP at that point? If we work with that third party to improve the design on our widget using a combination of their ideas and our ideas and their manufacturing resources, how does this affect the IP rights of the final design or any designs that may be based upon the original in some way? So I can a little bit long, but I think it's kind of back to that idea about the copyright. I think, you know, when I was surprised about, oh, I didn't know that someone else might own it even if I paid for it. So I think it's kind of that idea, along with not a written product, but a widget. You know, you hire someone to make this, who owns it, and is it even more complicated if that third party does some work on it, but maybe the original company or the hirer does some work on it too?
Yeah, Rob, you nailed it. That's exactly right. It's quite complicated. So what I would recommend in these situations is you always want to have a written agreement right at the forefront that sets out who's doing what, who owns what, and then you go from there. If you've already, you know, kind of gone down that road and there's no agreement, it's never too late to kind of sit down, take a step back and figure out whose rights, you know, because sometimes in a particular type of thing, be it a widget or whatever it is, computer software, you do have, it's almost like a bundle of IP rights. So there might be copyright there might be industrial designs, there might be trademarks, and you have different parties owning different things. So you just have to kind of sit down, come to an agreement and map it all out. But keep in mind that the default is whoever creates it. So if you, in the example provided, if you're working with a third party and they're creating some stuff and you're creating some stuff, whatever they create that's new and original, they would own. So it's quite important just to make sure that, you know, it's all in some sort of written agreement.
Great, very good. Thank you. Okay, great. Here's an interesting one. If a patent is issued and is later determined the patent process was published in an international journal, what happens to the patent? Is it grandfathered, accepted, or is it automatically invalidated?
I think it would be invalidated if the publication of the article was prior to the date of filing, because the invention is supposed to be non-obvious and novel as on the date of filing the application. So there are, I mean, there can be invalidity proceedings in court, but there are also proceedings, administrative proceedings before the patent office that cover this. So third parties can raise different kinds of objections to a granted patent even. So a granted patent is like by no means a guarantee that it will remain granted throughout the term. It can be challenged at any time, and definitely if the article predated the filing of application, then it can be grounds to invalidate because it would be non-obvious at that time in light of the article.
Okay. Okay, great question. I guess from the point of view of cost, should someone first apply for their patent in Canada or first start in another country and then come back to Canada?
I don't think it matters much like you still have to pay the filing fees for each office. There might be strategic advantage in terms of leniency of a patent office and that's how people time the filing in different countries under the PCT. So they file an application with the WIPO, and then if you get a patent granted in one geography, that adds some weight to your application in another office. So you need to strategically see for your particular claim set which patent office is known to take kindly to such inventions, and that's how you strategize the sequence. It's usually not based on the cost, because you still have to pay the filing fees for each office, and that remains the same. That's my understanding, but if Seepal, I'll let him.
No, I think that makes perfect sense. I mean, if in fact you are going to go that route and go into many jurisdictions, then you want to look at, where you could obtain that protection first. Yeah, I would totally agree. Yeah.
Okay, great. Seepal, this one's for you. Thanks for the presentation. Windsor has a significant automotive manufacturing base, mainly in tool and die. Given that most tier manufacturers produce OEM designed products, is there an unrealized opportunity to protect production methods or engineering design?
That's a good question. And I love the question about Windsor because that's my hometown. So thank you for that one. Yeah, I mean, that's a good question. It all goes back to, I mean, I don't know if you're referring to patent protection there, perhaps on the, or it all goes back to if it's, if it's a new novel idea, if it's non-obvious, if there's copyright protection there, is it in the public domain? Because if it's in the public domain, there's really nothing there anymore. Yeah, but I mean, it's a good question. I don't really have the answer for it, but yeah, I think it just goes back to what type of IP you're referring to in that particular process, and if it's, still, exclusive, and if there's rights there that can be afforded to it.
Okay, great. Here's another one. How do you protect confidential information from Google, Facebook, and others scraping that information from your communications? Oh, that's a good one. I don't know.
Yeah, I think that's a really actually good question, very timely, because it's happening every day. I mean, you can't really even speak inside your own home without somehow Google and Facebook, getting that information. So what I would say is you don't want to put anything online that is your trade secret, for example. Like if you have a trade secret or confidential information, as everybody does, every company, every enterprise has some information that's confidential. It's really important not to have it online. And there's a host of reasons for that, not just IP. There's also privacy concerns there that can come up quite often nowadays. So I think the key, Himja, I welcome your thoughts here too, but I think the key is to make sure that it's not getting on the internet, because I mean, as I tell my clients, as soon as something's on the internet, even if it's a secure website that has a password, you might as well assume that everybody has access to it. So things like Google Drive and Dropbox and all these things, there's always risk that they can be hacked, and third parties can obtain that information. So I know nowadays it's difficult to work with organizations in different places, people working from home. We really rely on these platforms like Google and whatnot. But if it's something that you're really concerned about, like your trade secret or financial information of your employees even, you want to really keep it as secure as possible. And off any sort of internet situation.
Yeah, I second everything that Seepal said, and to add to that, there's this phrase that network never forgets, and it's very true. If something's really intended to be secret, don't put it out on any platforms. Yeah, for sure. Okay,
good advice. Thank you. And I think we'll try and wrap up at 9:30. And thanks for answering all these questions. I hope you guys are, Himja and Seepal, are okay and your voices hold up. But just maybe one or two more. So here's an interesting one. When filing for a patent on a complex new invention, would using a component in that new invention that had already been patented somehow affect you? So maybe that component that you used for your own complex invention was patented and you didn't know about it. How does that affect any IP that you might want to pursue?
So it does not matter whether you knew about a prior art or not. It just has to be out there. If it's published, then you are. It's a constructive notice. You are assumed to have known and gone and done a prior art search about it. However, if there's one component in your patent that is somebody else has rights on that, and it's actually very common. So for example, if you get a patent on sodium chloride and somebody else has a patent on group 1 halides, which is a superset of sodium chloride, for example, you are still infringing on the broader patents. And this has happened. The patent office has granted patents which are supersets of other patents. What you need to do is reach out to this party who has a patent on a component or a superset or whatever you're infringing, get a license from them. Once you do that, they cannot bring an infringement proceeding against you because then you have their consent to use their patented invention.
Okay, great, thank you. So I think the last one is an NDA with a third party that specifies and describes the confidential information not to be disclosed. Is that effective protection prior to a patent application? So I guess if you're thinking ahead and down the road and you're pretty sure you want to patent something, is an NDA good enough, or are there other steps you need to take?
Like I mentioned, if this is an employee working for you or a third party even, but you want to retain the ownership rights to the IP, please have an invention assignment ahead of the patent filing, because when there are good chances of getting a patent, it might be difficult to get that agreement from the party. So get it right at the beginning, and an NDA, like a general NDA that includes all confidential information, including any potential intellectual property, etc., should be sufficient to cover the information contained in a patent application. But again, be sure to get it assigned to yourself.
Okay, great. Thanks so much. And Cpal, any last thoughts, or are we good on your end as well?
No, I mean, everything, it's all good. I think the only thing I would add that I was thinking about while we were kind of answering questions is just keep in mind when you have these assets, an important part that a lot of clients don't realize is there's also the enforcement of it. So you want to make sure just because you have your patent or your trademark or copyright registration doesn't mean that the Intellectual Property Office or WIPO is going to police it. So it's really important that you stop any third parties that are using a similar, trademark or copyright or patent, because what happens with a lot of our clients, especially in the trademark world, is they don't stop in third parties because, they feel bad or whatever it is. The third party is also doing great work and that sort of thing. But as soon as you have one or two users in the public, that right is lost, and you've spent all that money, registering and all these things. So enforcement side, I mean, I didn't have a chance to get into that, but it's equally as important as acquiring the rights and the assets.
Wow, great. I had never thought of that either. So things might be protected, but as you say, these patent agencies aren't the police. So that's up to you to search and keep looking for infringement, I suppose. Yeah,
you got it.
Wow. Okay, great. Lots to think about. So thanks again so much, Cpal and Himja. You can't see all the audience's applause, but there's lots out there. Thanks so much.
Thank you.
Thank you.
Thank you. As I mentioned earlier, please contact Julia. Here's her email for this session for other potential questions or follow-up questions or queries. And also, please keep a lookout for other event invitations. We have this industry breakfast every couple of months. We always try and deliver information that is useful to you. If you have thoughts on topics for upcoming breakfast events, please contact Julia or myself. We'd love to hear them. So again, thanks so much to our two speakers, and thanks to our audience for attending today. A lot of great information and so many great questions, and sorry we couldn't get to quite all of them, but I think we did a great job in getting them mostly answered in the time we had. So thanks again.